And our final speaker then is Iain Byrne from the Secretariat in Amnesty International. And Iain will discuss the new mechanism, or mechanism that will be coming into play quite shortly, the optional protocol on the International Covenant on Economic, Social and Cultural Rights. So Iain, thank
you. Thanks, Liam. Yes, folks, it's me again. Thank you for your attention on this session. And again, I'm gonna read from here. Not that I'm being lazy. It's just it's easier to look through my notes from this surface. As we've already discussed, I think the potential significance of the protocol, and with hopefully within the space of a few months, there will be a landmark event really in the international protection of human rights, because we now have 8 state ratifications of the protocol. Unfortunately, not yet Ireland, but it has signed it, and hopefully we will eventually end up with ratification here. And we need 10. So we're only 2 away, and we have good inside information in Amnesty through also the Economic and Social Rights Network that there's a couple of states, possibly one in Latin America and another one in Europe, that will soon be ratifying the protocol, and that will enable it to then come into force. And that will be about more than 4 decades after the sister treaty, the International Covenant on Civil and Political Rights, its complaint mechanism has come into force. And I think that says a lot of what we've been saying already today, and you're no doubt aware, was the kind of historic hierarchy, if you like, of rights that were reflected within the UN system. So despite all the language of indivisibility and interdependence dating back to the Universal Declaration reaffirmed in Vienna in 1993 that we've heard about, it's practically, we have seen a kind of a 2-tier system. But I think it's true to say during the last 2 decades, with the creation of a range of special procedure mechanisms addressing a range of rights such as health, housing, food, extreme poverty, education, etc., and with the UPR mechanism, which obviously focuses on both sets of rights, even if certain states haven't ratified the covenant, they are still going to be subject to the UPRs, as has been very well laid out for us. And now we've finally potentially got this complaints mechanism that is going to come into being. And it will not only potentially embrace, and I will go, and again, like Podrick, I'm not proposing to go into great detail about all of the, you'll be glad to know all of the different technical elements of this treaty, because I'm more interested in the potential of it or not, and some of the potential challenges of using the mechanism, and welcome a discussion on that. But just to go into sort of some of the summaries and also some of the potential benefits. But it will not only embrace an individual complaints mechanism, but also has the potential for an inquiry procedure. States will have to sign up to that, but that will mean that that will allow the committee to respond in a timely fashion to serious violations taking place within the territory of a state party. And it will offer potentially the means to address those systematic and widespread violations, particularly where people are afraid or unable to bring individual complaints. So you've got that twin duality going on within the protocol, which I think is going to be significant. And as I said, what would be the potential benefits of the protocol, some of which we've already gone through, but just to kind of go over some of them again. Now, obviously, at the heart of it is to provide potential remedy and redress for violations of rights that haven't been able to be rectified at the domestic level. And we know in many parts of the world there are no regional mechanisms. If you look at, in fact, I think the majority of the world's population don't have access to a regional mechanism. If you look at Asia Pacific, and the inability to be able to take individual complaints. You know, I like Podrick, and I've also litigated social charter, so I'm a great fan of the social charter. But again, we can see obviously, I think there are 2 deficiencies. One, the lack of an individual complaints mechanism, and also the inability of national NGOs to be able to bring complaints, which I think is a major deficiency of the charter as well, unless the state has declared that, which only Finland has. So it will provide and fill a gap that has been lacking generally, with 1 or 2 limited exceptions. And even the regional mechanisms, you know, they don't necessarily always embrace the whole range of economic and social rights. As I said, it will also help to clarify state obligations, and I think this is coming back to what we've been talking about. What is the added value sometimes of adopting an ESR approach? And it's easy for me to say, sitting here, I suppose, from civil society, but it's not something potentially that states should be afraid of. I think very much the committee sees it in line with its approach dating back to Philip Alston, the first chair of the Economic and Social Rights Committee back in the 80s, when he talked about a constructive dialogue with states. So yes, there is a naming and shaming element, and there is a finger-pointing element, but at the same time it is meant to have this constructive dialogue and to work with state parties to try and resolve some of these difficult and complex and challenging issues. And we all recognise that. There will be challenging issues. And the fact that, as I said in the session this morning, this will give the committee a challenge of having to deal with hard cases. So yes, the shadow reporting process is important, will continue to be important, but we know, having looked at some of those concluding observations, even though they have become more elaborate and detailed over time, that they are by their very nature discursive, and they can only range over a whole range of issues, and they can't really drill down, certainly to the extent that the Committee on Social Rights does on a collective complaint, or the potential for the UN committee now to drill down on individual complaints. And they will do, in so doing, they will obviously, hopefully, clarify to some of these fuzzy areas that Ignacio and others have talked about, the minimum core aspect of the rights, non-retrogression, budgetary analysis, potentially issues to do around the type of fiscal regime that is going to deliver economic and social rights. How far the committee will want to delve into some of these areas, how confident it will feel, and I think there is a real issue about capacity for a body that is not permanent, that is not, doesn't sit full time, that we know has traditionally been under-resourced. And sometimes, let's face it, the people that end up on these UN committees, they are not always of the caliber of expertise that we can expect. And the committee will shortly have a turnover. It will lose some quite experienced members. Obviously, new members will come on and hopefully bring different experiences and expertise to the issue. So I think there are challenges for the body itself. And this is all going on at the time. I think it's very important to say this. I want to have an honest assessment of challenges for the whole UN treaty body system. I think we have a multiplicity, we know that, of treaties now in existence, with potentially more maybe in terms of the elderly coming down the track. There is a multiplicity of reporting requirements in addition now to the UPR, and potentially we have the CEDAW, the Women's Convention complaints mechanism, and we have also the potential complaints mechanism on the Convention on the Rights of the Child. And these are all very important things. I was trying to promote having a complaints mechanism on the rights of the child 15, 20 years ago, and you were just, you were laughed out of, everywhere, because it just was seen to be totally unrealistic that children, God forbid, children would actually have, as victims, the right to take individual cases, even though, of course, they always had that right under the ICCPR, or their representatives did. But we are heading in that direction, but that does present real challenges for the system, and whether they are going to be able to adjudicate on these issues. But at the same time, it's going to have a lot of potential benefits, hopefully, at the national level. It can contribute to, obviously, the advancement of standards and the growth of jurisprudence. I think if we were having this discussion, 10, 15 years ago, before the South African jurisprudence had got up and running, before maybe the Committee on Social Rights had only heard a handful of cases, there is a lot more jurisprudence that has evolved. Obviously, there are places like South Asia which have been hearing economic and social rights cases for a long, long time and doesn't always get the attention. I think South Africa does get a lot of disproportionate attention for a relatively small number of cases. There is the growing corpus of law in Latin America doing some very interesting stuff, which we heard about, budgetary analysis. And there are many countries in Europe, in Scandinavia and Eastern Europe, who are also adjudicating cases. And I think you heard some of that from Aoife Nolan in the previous session. So there is a growing corpus of jurisprudence, but the committee itself, as the preeminent, I suppose, international body, will obviously, hopefully, be able to make a significant contribution to that at the same time. And I think a couple of other things just to highlight about the benefits is obviously, hopefully, will raise public awareness of ESCR issues, even if sometimes the cases are maybe not successful. And I had a very good example from Michael Farrell in the last session, and we've all got examples. I've certainly lost cases in different fora, in regional fora and international fora, but sometimes the impact of losing a case can still be significant because you've raised awareness about the issues and you've created a space within which the issues that the victims are facing can be debated, and sometimes that extra pressure, the naming and shaming, can actually have significant results. I'll just give you a very brief example. There was a case, a very high-profile case, lost in the South African Constitutional Court on right to water, Mazibuko, and got a lot of attention at the time and was seen as a trend for the Constitutional Court, unfortunately, to become more deferential to the executive. But actually the outcomes for the community were actually quite positive, and actually a lot of what they'd argued for in the court in terms of not having water meters, in terms of having actually more of a recognition of what they should need day to day as a minimum level of water in line with international standards, actually accepted. The reverse of that, there was a case about right to electricity, which was won but has never been implemented. And we've all been involved and still involved in many cases of cases that are just not being implemented. And of course, that again will be a challenge for, let's face it, for this UN body as well. If you look at the record of lack of implementation of Human Rights Committee decisions, I have to say it's relatively poor. I think the figures are somewhere in sort of 70 to 80% of decisions are not being implemented. And of course, people will say, well, it's going to be even worse when you come with economic and social rights cases. So that's why the issues have been raised, particularly by Podrick in the last session, about social movements, about tying in litigation to broader advocacy, to realise you're in it for the long haul. I mean, Amnesty International colleagues were in Prague only a couple of weeks ago trying to push yet again for a very emblematic case called DH versus the Czech Republic, which many of you will have heard of, about segregated education of Roma. Got a lot of attention, highlighted the issue yet again, but has never been implemented. And I have to say, most of the victims, or pretty much all the victims, and who've all been through the school system now and not seen any change, and in fact now their younger siblings are going through and still seeing the same impact. And you can see some of the recent reports we've just released if you go to our website on this issue. You know, for them, the cases that happened 5 years ago is they're completely removed from, and they're not, you know, and that's partly also the fault of civil society in terms of not keeping them in touch with what is happening. So there are real challenges there, but also it has the potential. I keep on saying yes, but it's kind of like, you know, back and forth. But I think that is the nature of these things. It is not a linear improvement. I think it is going to be 2 steps forward, 1 step back. But it is clearly an advance in many areas. I think it will raise public awareness of ESR, and also hopefully we talk about empowerment of individuals and civil society, but it will give them an extra voice. It will, I think, together with the UPR, with the social charter, if you work in Europe, these are all things that can come together sometimes to form a critical mass on an issue, and doing repeat litigation on an issue. You know, for example, now we may be thinking about doing a social charter case around the Czech Republic because they just recently signed up to that mechanism. So you have to you know, use these range of mechanisms that are available. As I said, I'm not going to go into detail in terms of the procedures. It is very similar to the existing treaty body procedures in terms of complaints. A couple of differences. One, they've introduced for the first time a time limit on non-exhaustion. So if you work in the regional system, obviously you'll be familiar with this. 6 months after you've exhausted domestic remedies, you must bring a case to the European Court of Human Rights, and the same in the Inter-America system. The UN system has traditionally not had that. They've introduced, it was a compromise, like a lot of these things, they eventually ended up with 1 year. So you've got an additional 6 months. And of course, again, given the complexity of some of these cases and pulling them together, that might be a challenge. And again, obviously, it begs the question of ensuring that particularly local NGOs and maybe local lawyers who are representing victims are given enough sufficient international support from people like, you know, Ignacio's organisation that can really help them with maybe putting together, I think, some of these key arguments that are going to resonate maybe around resource allocation, budgetary analysis, and some of the other things that might have to be wrestled with. And another innovation is Article 4, which the committee may decline to hear a complaint or communication if it doesn't reveal a clear disadvantage. Now, the important thing there is to emphasise may, so they're obviously, you know, it's an optional thing. And I think most of us feel, even though there was a strong civil society push to get this dropped, that most complaints will obviously, by their very nature, hopefully have a clear disadvantage. And it won't also be seen just to be limited to non-discrimination, which you might think would be the kind of angle to do around disadvantage. So that the most cases, because otherwise probably the case wouldn't meet the manifestly ill-founded criteria that would normally mean it's chucked out of court anyway without being heard. And then you've got all of the other things around anonymity and ensuring obviously it's compatible with the provisions of the covenant. In terms of the way that the committee is going to look at complaints, it has adopted the South African approach, which is this notion of reasonableness. And I think reasonableness is good. It provides a concept that I think most people understand. Obviously, if you're a common law lawyer, and in fact, I had the pleasure once of speaking to Arthur Chaskelson, the first president of the Constitutional Court, and Albie Sachs said, well, we came up with this great innovation, reasonableness. He said, well, no, we didn't really, because we were familiar with judicial review, administrative law, and for us this was a concept that we could grasp as a way of adjudication. The danger obviously is, and not adopting the so-called minimum core approach, is you could become, and I think you speak to South African NGOs and lawyers, there's a risk of becoming focused on the process as opposed to the outcomes, and also potentially being too deferential to the executive in how you define reasonableness. So obviously there will be challenges for the committee, and maybe if the committee is seen to be more progressive, maybe that will also kickstart the South African court, which does seem to have to be going through a little bit of a period, as all courts do, of seeing to be a little bit not as progressive as it was early on. So I think, I think I'll leave it there, and obviously again I welcome any questions or discussion. Thank you.